and welcome to another episode. This time round, you can see this is a different setup. I've got a lady hosting today, and we are talking about law, and yes, it is property law. And in case you've never been here before, my name is Taurai Jacks, TJ, and I do property every day. But we decided to bring you some cool friends of ours who are doing property from a law perspective. And today I'd like to introduce you to Pateka. And Pateka, she is from SSLR Incorporated. But before I continue rapping on, let me introduce you to the lady. Pateka, how are you?
I'm good. Thanks. And how are you?
Very well, thank you very much. Thanks you for coming in to give us the information, the good information that we need. We always say that when you're doing property, you always need to have a power team. And in your power team, it is important to have, one of the person needs to have a law hat. And not to mention, maybe we can say a law duke, seeing that you're wearing a duke.
Yes. Yes, we
Awesome
can say
stuff.
so.
Who is Phatheka before we jump on into the information that we want to talk about?
Phatheka is Phatheka Malipale, born and raised from Eastern Cape in Mthatha. I came to Johannesburg in 2003, obviously as everyone else, looking for greener pastures. So yeah, when I came here with my matric certificate and the National Diploma in Business Management, and everything else that happened after, I was in Joburg.
Awesome stuff. I had the privilege to work in Mthatha for about a year.
Okay.
So Standard Bank used to have the big cash depot there just in town, next to the head office of the law court. The court is behind, and Standard Bank used to be in the front there.
Yes, I see.
And they moved to another area. I can't really remember the area, but it's kind of like in an industrial area, sort of, that was coming up. And that was my project back in 2009, 10, somewhere there. I would jump on an aeroplane going to Mthatha. That aeroplane would be like, it was so scary, but we would get to Mthatha.
And I'm sure you enjoyed your stay there.
I did. So Mthatha is a very beautiful place. You come from a nice place. It gets cold though.
It does get cold in winter and sometimes in December. Yeah, don't get me wrong when I say December. Sometimes when you go home and you know that you want to enjoy your Christmas, by the 23rd of December, it's starting to get cold and raining. Yeah, but it is a very nice place. It is a very nice place.
Awesome stuff. Let's come back to your story, Pateka. And you started off at SSLR. When did you start with them?
I started with them in 2012, February. I started as a legal secretary. At the time, I was still completing my LLB. So I completed my LLB in 2013. So I graduated when I was there, served my articles there. And then I got admitted as an attorney in 2015, and then in 2016 as a conveyancer, and then in 2017 as a notary.
Wow. You have done everything at this firm. That's awesome.
Yes.
Okay. Congratulations on your journey so far.
Thank you.
And right now, I want to speak to the fact that you started off as a secretary. You could have gone through into different types of secretaries, but why did you gravitate to law, and why did you then actually become a lawyer?
Okay. When I came to Johannesburg in 2003, obviously I was just looking for a job. I was just looking for any job because at the time I didn't know much about law and I didn't even know what exactly. Obviously, in those days as a lady, you are just looking for a secretarial job.
Right.
So I was, and I must say that I was lucky to be employed by a law firm that was in Vereeniging. So that law firm, as you know, most of law firms, when they are starting up, they do everything. So we did a lot of divorces, a lot of property transfers. But what stood out for me was property law, because I guess then what was important for me was seeing the client's joy when you confirm the registration of the property, that it is now yours. And you hear people's excitement when they want to move and they want to paint and all of that. So I actually got so interested in this. I was like, you know what? Actually, let me get to UNISA and register to do my LLB, which I did.
Awesome stuff. There is many disciplines in law, and what do you focus in?
I focus mainly in property law. I focus mainly in property law. I know we have done, because when I joined the firm in 2012, they said to me, Pateka, we don't have a conveyancing department, so we just want someone who will be able to start up that department for us. And as a secretary, I was like, okay, let me accept the challenge. So I started the department, to obviously with the assistance of my directors, which is Selna Stein, as well as the then Elise Lerom. So for me, I never, I would say, get any interest in some other law, in terms of family law or criminal law or anything. But I guess as well, I was privileged to join them, whereas they were only specializing in property law.
Okay, awesome stuff. And today we have the privilege actually to talk about one of the law articles that we can actually jump into and talk about, which is the installment sale. And it is something that I like. I like it. I like to utilize that as a buying contract. We're always buying properties, and we're just going to dive into installment sale. What is an installment sale, and where did this come from? Actually, is it known as an installment sale? I mean, we always talk about it as an installment sale. What is the right terminology if that is not the correct name?
An installment sale agreement, yes, it is an installment sale agreement. It's described as a deed of alienation in terms of the Alienation of Land Act. So it's an agreement just like your sale agreement. But this agreement, the only difference is that it has got deferred payments. And with those deferred payments, then the nice thing, which I always encourage people who wants to, especially property investors who wants to venture into property, that, you know what, the nice thing about installment sale agreement is that it gets recorded. So it gets recorded at deeds office, and you as the purchaser of that property, then you get protected because of that recorder.
Awesome stuff. I like an installment sale. I've implemented a couple of times an installment sale. And, you know, the first time I actually stumbled upon it, it was really by mistake. I had read about it. And my estate agent actually was the person who really introduced me to it and say, we can do an installment sale on this property. And out of that, I literally fell in love with it because I realized that it is just an agreement between myself and the seller. So what I kind of like negotiate between myself and the seller is what goes, but there is some form of boundaries around it, right? And what are those boundaries, especially from an investor perspective? Because for me, I picked up three things, right? And Pateka here, you can correct me to say, TJ, there's others that you need to be wary about. The fact that an installment sale, it starts off, it clearly defines the timeline, not more than 5 years, not less than 30 months. So I know that I need to be playing in that space. So that's the one thing I really like about it. So it gives me time to plan.
Yes.
The second one that I also liked was that the fact that I can, once I buy this property and I've done a payment, right? Within a period of time, this property it has to be registered between the two of us. So I now know that for the period of time that I'm in, my investment money that I'm putting into here is also protected. for that period,
Yes.
right? And then the last thing that I learned and that I favor mostly is that the payments also are very structured in the guideline of an installment sale, that it needs to be not less than 3 payments. So which gives me the ability to negotiate how many payments I want to be making with the seller.
Yes.
Other than this, or should I say, these particular 3 ones that we spoke about, what are the most key important ones from a law perspective that you would see if I am the buyer and I'm an investor? What are the things that I need to be cautious around?
Okay. The first thing that I would like to highlight is that, again, it's an installment sale agreement and it is governed by Chapter 2 of the Alienation of Land Act. And
Right.
again, one of the most important things is that it must be recorded. It must be recorded against the title deed at the deeds office, because for you as the buyer, it's for your own protection, right? And then again, the property investors, what they need to know is that it is mainly for residential purposes. So meaning if you manage to find that vacant stand, which is zoned agricultural, then that one is not for installment sale. So meaning you cannot approach the owner of that vacant stand and ask for a contract in terms of this Alienation of Land Act. So
maybe let me jump in there, Pateka. So I want to come back to when you're saying that the good thing about it is that it has to be recorded. What do we mean there? Because I think for many of when I hear recorded from your end, I mean, oh, so does the property now belongs to me? Let's explain a little bit more there on the recording part.
On the recording part, okay. So an installment sale agreement, when it's signed between the parties, that is now when all the parties have negotiated the repayments and the purchase price. So
Right.
what we do then as conveyancers, we then request the securities, because sometimes you find out that the owner of the property still has a bond on that property. So what we do then, we approach the bank where the bond is held, and then we request the bank's consent for us to record the contract. So what we do then, the reason why we request a consent is because the bank is holding the security documents, that is your original title deed as well as your bond name. Now we need to get that, because when we record, we are endorsing the title deed to the effect that there is an installment sale agreement in this property. So we have never had a situation where, for example, the bank is refusing to give us a consent. So what we then merely do is we take the title deed together with the installment sale agreement, we submit it to the deeds office for it to be recorded. Then when you do your wind deed search, that's where you will notice that there is an endorsement against this property, of which then, because it mostly happens that when someone is purchasing a property, then you want to see all the endorsements that are there at the interdict and all of that. So what you do then, when you see that installment sale agreement, then you must know that the property was sold to someone else. Then in that case, you obviously have to do your own investigation to find out what happened in that installment sale agreement. So the reasoning again behind the recordal of the installment sale agreement is, one, for your own protection as the purchaser, because in terms of the act, the seller is not entitled to your payments as the purchaser. The payments that you will be making against the purchase price, those payments are only due to the owner of the property when the recordal has been done. So before the recordal, they will merely pay those payments to the attorney for investment. The owner of the property can only be entitled to them as soon as the recordal is done.
Right. So you mentioned a couple of new words to us there. And the first one was that you mentioned that if one goes in search a wind deed, and I just want to clarify, the wind deed is one of the reports that you can get, you can pull. There's plenty of them, TPN, Lightstone.
TPN, Lightstone, yes.
right? And you can, those are some of the tools that you need as an investor to see the owner of the property, right?
Yes.
And I want to stress or come back to the point, Pateka, where you're talking about your example that you have utilized here is taking the assumption that this person that we are doing an installment with, the seller, has a bond. And I've
Yes.
had a lot of people saying you cannot do an installment sale with someone that that has a bond. But you are saying it is possible. You need to
Yes.
work with the right conveyancer, and
Yes.
then it is recorded. But the bank also needs to give consent.
Consent, yes.
Right. So if the bank has given consent, what is the process there now? Does the bank needs to vet me to stipulate that I can make the repayment? Will the bank ask of that during your consent period?
No, the bank does not ask for that, because what we do is when we communicate with the bank, we send the bank a copy of the contract, and then
Right.
we advise the bank that we are about to record it, so we just need them to give us a consent. So as I was saying, we have never had a situation where the bank is refusing to grant us that consent.
Okay.
Yes.
Let's assume John Pateka, John is the seller of this property and I'm the buyer in this case, right?
Yes, yes.
And so does it mean that John will still be liable for the debt at the bank? And then I am now the second person who's also liable, seeing that the bank would have given consent. Is that the case here?
No, it is not the case. What I usually advise the property investors is that when there is a bond on the property, one, you need to find out on the conclusion, not after you have signed the contract, while you are still negotiating the installment sale contract. So you need to find out if there is a bond on the property. Then
Right.
if there is a bond, you need to find out how much what is the value of that bond amount. So
Right.
the reason for that, obviously you want to know you're not getting yourself into a situation whereby there's this higher amount of bond that is still due to be paid, and yet you are negotiating a lesser price, for example, because you can negotiate a 500,000 rand, whereas the owner of the property still owes the bank 800,000. So those are the other things that are important for you as a property investor to check. So now coming to the situation where now there is a bond on the property. Sorry. So what happens is the bank is giving us a consent, not obviously to say we are sharing now the responsibility of the owner for you as a new owner of this property or the prospective buyer. So what we're saying is, one, on the installment sale agreement, you will then request the seller of the owner of the property to give you the details, because it's important for you to make sure that the installments that you will be paying, they will be utilized towards the bond repayments, because you don't want a situation whereby you are paying the owner of the property money and then the owner is not paying the bank. I had an issue like that some 2-3 years ago. They agreed that no, we don't want you to pay to the bank. And then the purchaser was paying directly to the owner of the property. And then what happens is that then the property was sold on auction because the guy was defaulting.
Oh,
So
you
now
lost your money.
remember, exactly. Remember now, you also negotiated in terms of that agreement that, okay, I would want to occupy the property. So
Yeah.
occupying the property, obviously you want to repaint the property, then you get a consent from the owner to do some renovations. Now the renovations are already done, and now the owner of the property defaulted, then it becomes a problem, because now you will only be left to claim whatever the renovations or whatever you have done in the property to upgrade to the value that you would want the property to have while you are occupying, because obviously the intention was for you to own the property.
So who do you pay then in that circumstance, Pateka? How, like, when you're making those payments, where those payments are going to go? Like, for instance, in these days, we get to see a lot of banks giving what they call flex. I mean, each bank calls it differently, but What I'm trying to say here is that the more you're going to pay in your bond account, then the bank is loosening up some money as well. So who's the account holder can use that money. So who do you pay in this circumstance?
You know what? I think in this circumstance, what is important is for you to pay directly to the bank. There is a clause as well on that contract that says that the owner of the property is not allowed to do some withdrawals. So you're not allowed to withdraw anything there. So, but then again, I think the withdrawal it depends on what type of a bond. Because if a bond is a flexi bond, yes, then you have to make sure that you get your statements every month so that you know that there is no withdrawal. So otherwise, there is a clause in the contract that says that the owner is not allowed to do any withdrawals on the bond, and that you are also paying towards the bank. I mean, towards the bond. You don't pay directly to the owner. Some people, they usually choose, for example, if you know, because obviously some other property investors, they decide they're not going to keep the property for longer. Let's say, for example, for a year. And then you say, you know what, instead of me having to pay to the guy, or I mean to the owner or to the bank, so I'll rather pay to the attorney, and then the attorney must just invest my money until I know, because obviously as property investors, there's always, it's either you have an intention to reside in the property, or the intention is to renovate and resell. So depending, then it's always advisable to some, depending again on your intention, to pay those installments to the conveyancing attorney for them to be invested.
Okay. I think I also like the second one here, but I think what we are demonstrating here is that each situation is very different.
It's different. Yes.
And you need to be working with a person like you who would look at all the angles and say the right contract for this particular property is this one, given the circumstance of the seller and the circumstance of the buyer as well. So each installment sale agreement is very different from one to the next
Exact, which is why we cannot even share, because I know at SSLR Incorporated, we do share our sale agreements, that is the OTP. So those offer to purchases that we share, they have got their own standard terms of which you can add there and there. But an installment sale agreement, it's not something that you can share, because it's designed for that specific transaction. As we say, it's totally different from each other. So we cannot say, for example, you can't ask me to give you a copy. No, I can only advise you on the terms and the conditions that you can put, but obviously those terms and conditions were only drafted for you only, not for the other person.
100%. And I'm sure this is going out to all my brothers there. They are always asking me, TJ, let me have your copy, man. Just give me your template. And I'm always saying to them, guys, it's not about that. You really need to look into the bigger picture yourself, the seller. Right. Okay. Awesome stuff. Let's look at the same scenario, Pateka, here, right? However, in a different circumstance where the seller actually owns the property outright. There is no bond involved here.
There's no bond involved. Yes. If there is no bond involved, then it's quite easy. If there is no bond, because then you don't have to stress yourself about having to pay directly to the bank and worried about what if. So if there is no bond, it's very nice, although obviously it's still, in terms of the act, has to be recorded, because it's important for you as well as the purchaser that it must be recorded. So you can then agree with in terms of your negotiations with the owner of the property as to, okay, how would I pay? Then they usually, because the first installments, the first to third or fourth installment, usually they pay to the conveyancer until the recordal is done. As soon as the recordal is done, then we can release the money to the owner, and then from there you pay directly to the owner.
You mentioned the period of recording here, and I want us to jump into it a little bit and unpack it. When we are saying that we are going to record, my understanding here with what you have said so far is that my name together with the seller, both of our names are on there now, and that the seller can't go and sell the property now. actually without my consent, or I will know about it if they want to sell it, which means that the other conveyancer won't be able to execute that. So that's the first thing that I'm hearing here.
Yes.
But the second thing that I'm also hearing here is that based on the type of a deal, if it's a bond, there's another layer of big brother that we need to go to, which is the bank, get consent and all of that. But now, if it is the actual seller who owns this property, potentially they have their title deed with them. If they don't have it, there's another process that you need to follow to get that.
Follow to get a copy, yes.
Right? And then secondly, now, you now need to record the title deed. So the recording plays a role here between, even if it is cash or even if it is a bond.
It's a bond, yes.
How long is that recording? Like, is there a time frame where it's stipulated that by X time the recording needs to have happened?
No, there is no stipulated time. Because I would say it's a matter of 4 weeks for the recorder to be finalized at the deeds office. The reason why I'm saying 4 weeks, I'm accommodating the fact that we need to obtain a consent from the bank. So usually it's a process that takes them 2 weeks or a week, because they have to get the title deed back from their securities department before they can issue us with the consent and deliver the title deeds to us. So that is why I'm saying 4 weeks. But other than that, let's say then that the owner has got the original title deed. Then in that case, it's just a matter of taking the original signed installment sale agreement with the original title deed and submitting it to the deeds office. And then again, the other important thing, which is what I would want to mention to the property investors, is that there is transfer duty that is payable, and that transfer duty has to be paid within a period of 6 months. So now, because obviously our installment sale agreement is for a period over and above the 6 months, so we just have to make sure that if there is transfer duty payable, that transfer duty, you are aware that it needs to be paid within a period of 6 months to avoid penalties. So then in this case, the other document that I need to get is that transfer duty receipt to submit together with the recorder. It's nice if, for example, it's below R1 million where there's no transfer duty payable, but if it's over and above that, then in that case, you must know. We can still record it without it, but just for you to know, you have to pay it within a period of 6 months.
Awesome stuff. Is there a limited time? Earlier on I did say that my understanding is that an installment sale must not be less than 13 months, but I just want to clarify that with you. So is there a time frame that an installment sale should be and not exceed? So is there a minimum? And is there also like a time frame that we shouldn't exceed? It should be within that space. I understood it as anything from 13, nothing less than a year, and nothing more than 5 years. But I didn't study law here. Maybe I didn't interpret it correctly.
Okay. In terms of the definition of the installment sale agreement,
right.
Okay, I said earlier that it is a deed of alienation, right? Whereby land is sold against payment by the purchaser to the seller or to any person on behalf of the seller of an amount of money. One, in more than 2 installments, and then 2 over a period exceeding 1 year.
Okay. So is there a maximum? So my 1 year comes in here now, right? So that's, but now, is there a maximum that we should not exceed?
5 years. Our maximum, it must not be more than 5 years.
All right, good. Happiness. I think I qualify for 1 year of law exemption when I go and do my law.
So you were right. You do qualify. You do qualify.
Awesome stuff. Now, Pateka, I want us to come through into maybe a scenario that where you have seen an installment sale going very bad. Are there situations like that? And what is the worst case that can happen?
Okay, I think I would mention the one I mentioned earlier.
You're right.
We drafted the installment sale agreement. They obviously were negotiations, and there was a payment towards the installment, but the payments were made directly to the owner of the property. And unfortunately, it appeared that the owner of the property did not pay the bank. So meaning he defaulted on bond repayments. So
Right.
so now the purchaser then approached us and is like, you know what, Pateka, this is what is happening now. I just got these summons that were served by the bank to the property, and I forwarded this to the owner, and the owner was telling me that, you know what, guys, I'm sorry, I was going through some difficult time, and that is why I couldn't pay the bond. And then obviously it was like now kind of like a dispute, because how are you collecting money from me and not paying it to the bank? And knowing for a fact that I'm already occupying the property, one, and then two, and knowing that you have given me consent to renovate this property. So that was the biggest problem, which I think most of the property investors, it's important for them to know from the onset on the negotiation stage. They need to do their own due diligence on the property and the owner of the property in terms of, one, is there bond on the property? Two, are there any other interdicts on the property? And then three, negotiate the payments, because I know some of the sellers, you get those distressed sellers, and obviously the distressed sellers, they are unable to pay the rent, they are unable to pay the municipality, they are unable to pay the levies on the body corporate. So you must just be able to, which is why I'm saying it can't be a template. You can't give it to someone as a template. You have to sit down and look around that specific transaction and be able to take an informed decision, knowing for a fact that, okay, this is what I'm letting myself in. And again, knowing that if there is a bond on the property and the owner of the property is refusing for you to pay the installments towards the bank, I mean the bond, and then he wants the installment to be paid directly to him, then you need to know what you need to do. For example, you need to know that you need, because in terms of the act does say that the owners need to provide you with a statement. You need to be provided with the bond statement every month, so you know that there is payment that is being made. Then you don't see yourself getting into a situation where you have paid like over 100,000 rand, and yet the property is going to be repossessed.
I didn't know about that statement. Actually, this is new for me. Okay, awesome. Thank you, Pateka.
It's a pleasure. Thank you so much.
Awesome stuff. Cheers, cheers.
Thanks. Bye.
Bye-bye.